Force majeure, how it applies to small businesses. Introduction. The COVID-19 pandemic and other global disruptions have underscored the importance of force majeure clauses in business contracts. Small businesses, particularly those in construction, real estate, and employment services, often face heightened risks due to limited resources and contract rigidity. By understanding the scope and applications of force majeure, business owners and legal professionals can better navigate the challenges posed by unforeseen events. This video examines how force majeure applies to small businesses, explores recent legal developments, and offers recommendations to strengthen contracts and minimize disputes. Please note, this video should be used for learning and illustrative purposes. It is not a substitute for consultation with an attorney with expertise in this area. If you have any questions about a specific legal issue, we always recommend that you consult an attorney to discuss the particulars of your case. Definition and scope of force majeure. Force majeure operates differently in various legal systems. In common law jurisdictions like the United States, courts do not automatically recognize force majeure unless it is explicitly outlined in a contract. This makes the precise wording of force majeure clauses critical. Businesses that fail to define the scope of qualifying events or provide for timely notice may find their claims rejected in court. In the sections that follow, this video will explore how force majeure applies to small businesses in sectors such as construction, real estate, and employment services, highlighting the practical strategies for minimizing legal and financial risks. Importance of force majeure for small businesses. Small businesses are particularly vulnerable to disruptions caused by force majeure events due to their limited resources and financial flexibility. Below are critical areas where force majeure clauses have significant importance. Business continuity and financial stability. When a force majeure event halts operations, small businesses may struggle to meet financial obligations like loan payments, supplier contracts, or rent. Force majeure clauses allow businesses to suspend or renegotiate contract terms, providing temporary relief during crises. Example, during the pandemic, many small retail businesses invoked force majeure to negotiate deferred rent payments when lockdowns forced them to close. Supplier and supply chain management. Supply chain disruptions can prevent businesses from obtaining critical materials or products. Force majeure clauses in supplier agreements provide protection against penalties for non-performance. Industry example. Small construction firms experienced severe delays during the COVID-19 pandemic due to shortages of imported materials. Those with force majeure clauses were able to avoid litigation and negotiate new timelines. Real estate and lease agreements. Commercial tenants, especially small businesses, have faced disputes over rent obligations during government-mandated closures. Tenants who successfully invoked force majeure were able to suspend payments temporarily without breaching their lease agreements. Legal case. In Encinas v. Real Property Trustees 2020, a tenant's claim was upheld because the lease included explicit provisions for force majeure during government-imposed shutdowns. Employment and workforce management. Force majeure may affect employee contracts, particularly when businesses are forced to shut down temporarily or reduce staffing. However, courts are cautious about applying force majeure to justify layoffs unless explicitly provided in the employment agreement. Example: courts have rejected claims where businesses cited force majeure without showing a direct legal or operational impossibility in continuing employment. Insurance, risk, and management. Force majeure clauses often intersect with business interruption insurance. Small businesses should ensure that their contracts and insurance policies are aligned to avoid gaps in coverage during major disruptions. Recent trends in court interpretation. Recent case law has highlighted evolving interpretations of force majeure clauses. Foreseeability. Initially, courts were more willing to accept pandemic-related force majeure claims because the scope and impact of COVID-19 were considered unforeseeable. However, as the pandemic progressed, courts began to scrutinize claims related to predictable issues like ongoing supply chain delays. Causation. Courts require businesses to demonstrate that the force majeure event directly caused the inability to perform contractual obligations. General financial hardship is not sufficient grounds for invoking force majeure. Example: in a construction dispute, the court ruled against a contractor who cited force majeure without providing a direct link between material shortages and government lockdowns. Sector-specific applications. Construction. Force majeure clauses are particularly important in construction contracts where delays can have significant financial and legal consequences. Common events include natural disasters, labor strikes, and regulatory changes. Real estate. Commercial real estate contracts have seen increased litigation over rent obligations and force majeure defenses. Tenants are more frequently negotiating for broader force majeure coverage in lease agreements. Employment. Force majeure claims in employment disputes have faced heightened scrutiny as courts typically expect employers to fulfill contractual obligations unless performance is legally or physically impossible. Case studies. Case 1. Construction disruption in Florida. A contractor sought relief under a force majeure clause after hurricanes disrupted supply deliveries. The court ruled in favor of the contractor, emphasizing contract's explicit mention of hurricanes as qualifying events. Case 2. Retail lease dispute. A small retailer in Texas successfully invoked force majeure to defer rent payments during government-imposed store closures. The court upheld the claim, citing the tenant's compliance with notice provisions and the clause's reference to government regulations. Recommendations for small businesses. Draft clear clauses. Ensure force majeure clauses define specific events, for example, pandemics and natural disasters, and procedures for invoking the clause. Provide timely notice. Comply with notice requirements to maintain the right to claim force majeure. Mitigate risks. Develop contingency plans and document the impact of disruptions on operations. Align insurance coverage. Review business interruption policies to ensure they cover events listed in force majeure clauses. Conclusion. Force majeure has become a critical tool for small businesses navigating the uncertainties of a globalized and unpredictable economy. By incorporating clear and enforceable clauses in contracts, businesses can protect themselves against unforeseen events and reduce the risk of costly legal disputes. For legal professionals, staying abreast of evolving interpretations of force majeure is essential to providing effective guidance to clients. Contact Tishkoff. Tishkoff PLC specializes in business law and litigation. For inquiries, contact us at www.tish.law/contact. Check out Tishkoff PLC's website at www.tish.law. Ebooks at www.tish.law/e-books. Blogs at www.tish.law/blog. And references at www.tish.law/resources.